Hi, I'm Vincent Rosillo, a partner in the law firm of Fine, Olin and Andaman. We get a lot of questions regarding eligibility for workers' compensation, and one of the most commonly asked questions is, am I eligible for workers' compensation benefits if I have an accident while I'm on a lunch break or a coffee break while out to work? Today, I'm here with Patricia Fontaine, who's an attorney that works primarily out of our Long Island office. Welcome, Patricia.
Good morning, Vinny. How are you?
Good. Whether an accident is covered under the workers' compensation law depends a lot on the specific facts, but generally, are accidents that occur during lunch or on a break covered?
It is possible that accidents that occur during lunch or on a break can be covered, but as you said, so much depends upon the specific facts. For instance, if someone leaves their work location to get lunch and is hit by a car while crossing the street, they would not be covered under the law. Remember, to be covered, accidents have to arise out of and in the course of employment. So, unless they left the building to do more than just buy lunch, they would not be covered. I also think the judges look to see if there was some type of benefit to the employer.
That's a good point. Would the employee be covered if they were going to a business lunch or even if the employer had paid for lunch?
Certainly, the employee would be covered if they were going to a business lunch, and the case where the employer paid for lunch, it is possible that it would be covered if it was proven that the employer gained the benefits such as improved morale.
Interesting, but let's change the facts a little bit. What happens if they remained in the building and slipped and fell in the company's cafeteria?
They would be covered. Workers' compensation covers people who have had an accident on the employer's premises while out to lunch or on a break.
So even if the employee signed out for lunch or for the coffee break, would they be covered as long as they were on the premises?
Generally, yes.
What if the employee is outside smoking a cigarette on a break?
If the break is relatively short and the accident happened near the building while on a break, that person would be covered.
You know, we get a lot of questions from people who are playing a game during lunch, and I know these scenarios are so fact specific, but what's the general rule?
Those can be tough cases. In order for it to be covered, the employer has to have had knowledge that the games were being played and derive some type of benefit from the games. Again, whether company morale was improved, for example.
Let's talk about someone who doesn't work out of a particular office. For instance, someone who's constantly on the road visiting clients or customers. Would they be covered if they had an accident while having lunch?
Yes, the law considers those type of employees to be outside employees. These type of employees or workers are covered from the moment they leave home. So for example, they would be covered if there was an accident, they were hit by a car going to get lunch in between seeing clients.
You know, we have a few cases where an employee is an inside worker but gets sent by their boss to do a specific task. And before returning to the office, they stop to get lunch and have an accident. Would that be covered?
Yes. The more control that an employer has, the more likely it is to be covered. In that situation, the employer sent the employee somewhere, the employee's deviation was minor and insignificant.
Since these accidents occur during lunch or while on a break, I would think it would be important for the injured worker to make it clear to their doctor that it's a workers' compensation case.
Definitely. When doctors hear that the accident happened while at lunch or on a break, they think workers' compensation does not apply and use the employee's private health insurance, which could create more confusion. The injured employee should make it clear at the first visit that this is a workers' compensation claim to the doctor.
Especially, I think, if a car is involved, because then no fault insurance gets involved and makes it more complicated. You know, as in all workers' compensation cases, the injured employee must notify their employer of the accident. Much time does an injured worker have to report an accident to their employer?
The injured worker has 30 days from the date of the accident to give notice to the employer, a supervisor, someone, and an authority figure, someone who's controlling them, either in writing or verbally. Within 30 days, they have to notify.
In addition to give a notice, an injured worker must also file a claim with the New York State Workers' Compensation Board. How much time does a person have to file a claim with the state of New York?
The injured worker has 2 years from the date of accident to file a workers' compensation claim in the state of New York.
Patricia, thanks for taking the time today to discuss this issue. I think we've clarified an area of the law that can be quite confusing.
You're welcome. This area of the law is confusing, and since it is very fact specific, people should contact an attorney before making a decision as to whether or not they should file a claim for workers' compensation.
I agree, especially since we don't charge a consultation fee, and under the workers' compensation law, an attorney can only get paid if there is an award made in a compensation case, so it makes sense to contact an attorney. And we could be contacted at www.foalaw.com, or we can be reached by telephone at 1-800-522-9001. Thanks again, Patricia.
You're welcome. Have a great day.
You too.